Hello, my name is Josh McMahon, and I'm doing my presentation on U.S. corporate codes and EU privacy laws. U.S. companies in the EU are going to have a hard time getting up to speed with the EU laws due to their strict privacy laws. In 2016, the EU started to change their data privacy laws, and they went into effect in 2018. The sooner the U.S. companies started to work on updating their own privacy laws, the better. The EU has some of the strongest data privacy laws in the world. France reinforced their laws in June 2018. These new laws amended the existing French Data Protection Act. When they were working on the new laws, they temporarily suspended international data. To comply with the general data protection regulations, the scope of sensitive data has been broadened and now includes genetic data, biometric data, and data relating to the sexual orientation of a data subject. The GDPR creates exceptions to the general prohibition to process sensitive personal data and gives flexibility to the member states to implement additional expectations. The French Data Protection Act uses such expectations, for example, by authorizing the processing of biometric data when it's strictly necessary to control the access to the workplace to computers and applications used at work. Article 8 in the GDPR allows national legislation to lower the age limit for the processing of personal data on minors in the context of information society services. In France, the age for digital majority has now been set at 15, which means that from the age of 15, a minor can consent to his or her data processing. Therefore, data controllers have to make sure that they use a clear and accessible language in order to obtain the informed consent of minors. However, for children below 15, personal data processing is lawful only if the consent is obtained jointly by the minor concerned and the holder of the parental responsibility. One of the most significant changes regarding data subjects' rights concerns minors. Indeed, minors above 15 years can exercise their data protection rights without notifying their parents or legal guardian in relation to the processing of their health data for certain types of medical research and studies or evaluations. Data protection in Germany. The German Federal Data Protection Act came into effect in a new version on May 2018. The FDPA provides specific provisions for the federal public sector, but also provisions for the private sector, which are based in certain opening clauses contained in the GDPR. The 16 German federal states also have the state-level data protection laws, which also can be adapted to the GDPR. These new laws only apply to the public sector in relevant states. The Telecommunications Act contains sector-specific data protection provisions that apply to the telecommunication services providers such as internet access providers. Processing of personal data is lawful only if and to the extent that it is permitted under the EU data protection laws. The GDPR provides an exhaustive list of legal bases on which personal data may be processed. Challenges for the U.S. For U.S. companies that don't comply with the new laws, they could be in a lot of trouble. They could face penalties in the millions of dollars. It wouldn't be easy for some U.S. companies to get ready for the GDPR because they are so far behind when it comes to data privacy. When they look into the U.S. companies that would be affected by the new laws, it was shown that smaller corporations would not be prepared to easily transition to these new laws. When they tested them, it looked like they were only about 10% ready. And this only applies to like smaller companies. They also checked the larger companies who were more ready than the smaller companies, being around 80 to 90% compliable with the new laws, but no companies in the U.S. were 100% ready for these new laws. And that is my presentation. I hope you enjoyed it. Thank you.